Good afternoon, everyone, and welcome to the League of Women Voters of Santa Barbara's Forum on Public Safety Beyond Police and Prisons. I'm Vijaya Jamalamadaka, president of our local league. This forum is being co-sponsored by our friends at CLUE. CLUE is the Clergy and Laity United for Economic Justice in Santa Barbara. And then it's also being co-sponsored by the Fund for Santa Barbara and TVSB. So a warm welcome to our distinguished panelists. This program is being recorded and also being live streamed on, we probably aren't live streaming it on Facebook at this time. Simultaneous Spanish interpretation is being provided by Silvia Uribe of Transil Pro. And now I would like to introduce Tonia Guerrero to give you the instructions on how to access the simultaneous interpretation in Spanish.
Sí, gracias. Buenas tardes. En la parte inferior de su pantalla encontrará el símbolo del mundo. Haga clic sobre él y le aparecerá la opción para escoger español. Haga clic y listo. Usted escuchará la presentación en español. Gracias.
Thank you, Tonia. Tonia will also be recording in Spanish for us. And we will so now, before we start, I would like to respectfully acknowledge that the land we are on is the unceded territory of the Chumash people of Santa Barbara. We pay our respects to the Chumash elders, past, present, and future, who call this place their home. May we follow in your tradition of coming together and growing as a community. We thank the Chumash community for their stewardship and wisdom and welcome them as we seek a healing path for all people and the earth. A little bit about the League of Women Voters. The League is a 101-year-old organization. We work at the national, state, and local levels on issues of concern to our communities. The League believes in the power of women to create a more perfect democracy, a democracy where every person has the right, the desire, the knowledge, and the confidence to participate. Our local league is an all-volunteer nonprofit. League membership is open to anyone over 16 years of age, and please check out our website and join us if you're not already a member. So this is the last forum of the year, and we will begin again next year with a special League birthday forum in February. You will not want to miss that. We invite you to add your questions to the Q&A during the discussion, and our moderator will ask the panelists to answer them as we are able, and hopefully at the end during Q&A time. We apologize in advance if we're not able to respond to every question. A big thank you to our forum organizers, Gail Osharenko, Laura Pina, Pam Flint-Tambo, who is our Vice President of Programs and Social Policy. Pam is behind the scenes monitoring the webinar, and she's worked very hard on the setup and the Q&A box for your questions. So as is our tradition, the League will hold a discussion group on Zoom so that the members who can have an informal dialogue with Pam and Gail for more information. The this follow-up session is set for December 1st. Please see our website calendar or email our VP Programs, Pam Flint-Tambo, from our website for the Zoom link to join. And now I'd like to introduce our moderator, retired Superior Court Judge George Eskin. Judge Eskin has been working in the criminal justice system as a prosecutor, defense attorney, and judge for the past 56 years. He served as an assistant district attorney in both Ventura County and Santa Barbara County, and as Chief Assistant City Attorney in Los Angeles. He was certified as a specialist in criminal law by the State Bar of California, and he has served on statewide commissions and committees dedicated to the administration of criminal justice. Judge Eskin, you're on.
Thank you, Vijaya. The prison population in California increased from 20,000 inmates in 1977 to over 160,000 inmates in 2006, more than double the prison design capacity. Federal courts intervened then and ordered California to reduce its prison population and address the inhumane conditions that had been created. In 2011, just 10 years ago, the legislature adopted Assembly Bill number 109, known as Realignment, expanding the role of community corrections officer efforts and transferring responsibility for supervising some felony offenders and state prison parolees to county jails and probation officers in a program called Post-Release Community Supervision. The following year, in 2012, California's voters adopted Proposition 36, which revised the three strikes law and authorized judges to re-sentence inmates after a determination that they no longer posed a public safety risk. In 2014, the voters adopted Proposition 47, converting many nonviolent theft and drug offenses from felony to misdemeanor status, eliminating state prison as a potential penalty, and contributing to financial savings that have been invested in drug and mental health treatment programs throughout the state. In 2016, the voters adopted Proposition 57, allowing parole consideration for persons convicted of nonviolent crimes after they had served the sentence for the underlying offense, but not the aggravating enhancements. It also changed juvenile prosecution procedures and authorized custody credits for good behavior. All of these initiatives were opposed by our sheriff and district attorney. The average daily state prison adult population has been reduced by over 40,000. California inmates are no longer incarcerated in other states. And it's important to emphasize that despite the warnings of fearmongers, California crime rates declined by 12% during the 10-year period between 2010 to 2019, according to the State Department of Justice. Santa Barbara County Executive Officer Mona Miyasato has recognized the importance of coordinating the efforts of criminal justice agencies and the independent third branch of government, the Superior Court. The CEO and the Board of Supervisors have pursued several programs designed to reduce the jail population without compromising public safety. A community corrections partnership, the CCP, was established pursuant to the authority of the Realignment Statute. The State Judicial Council awarded Santa Barbara County $1.6 million in 2019 to expand its pretrial pilot project. A successful co-response team was created to deal with incidents involving people whose behavior is associated with mental health issues. Going forward, the Board of Supervisors is currently studying its options regarding the imminent opening of a new jail facility in Santa Maria and what to do with the decrepit main jail facility in Santa Barbara. The League of Women Voters has gathered a distinguished panel to discuss these issues today, and I'm pleased to welcome Tanya Heitman, Chief Probation Officer, who served the County of Santa Barbara for 31 years in various positions throughout the probation department and on numerous state committees related to program oversight, funding, and data collection and analysis. Tracy Makuga, Santa Barbara's public defender for approximately 5 years, a graduate of Chicago's Loyola University and the Cal Western College of Law, previously served in the public defender offices in both San Diego and Riverside counties. Chief Assistant Public Defender LaMare Kyle Griffiths, a University of Dayton School of Law graduate who's devoted her career to indigent criminal defense in Boston, Seattle, in the state of Kentucky, and the state of Oklahoma. She's litigated death penalty trials and served as an adjunct professor at Seattle University College of Law, the University of Iowa Law School, coach of the Boston College mock trial team, and at Harvard Law School's Trial Advocacy Workshop. Laura Pina, an academic counselor at Santa Barbara City College with a master's degree in clinical psychology from Antioch University, a Santa Barbara native who attended local schools and is committed to change for a better community and our criminal justice system, with a particular emphasis on women's issues and the challenges facing those who have been incarcerated. And Pastor Jerry Menchaca, founder of the New Beginnings Community Church, a native of Santa Barbara and longtime advocate for youth, who's devoted his adult life to the development of successful gang intervention programs and the Boys to Men Youth Mentorship Program. Let's start with the newcomer to our community. Welcome to Santa Barbara, LaMare. You've been with us for a few months, and after extensive experience in other states, please share with us your overall impressions about the administration of criminal justice in Santa Barbara County.
Thank you for the warm welcome, and I am very excited to be in Santa Barbara and to have this as my next part of my journey. The interesting thing about moving to a new place, as I've done it many times, is not as much of the differences, but the similarities. What I have seen in the 4 other states I have been in is very similar to what I have seen in my short time in Santa Barbara. The main thrust has been the effect on others of what happens in the mass involvement of the criminal system in people's lives. There are ripple effects that occur when someone is incarcerated. If that person is a father, a brother, a sister, a friend. And there are studies out, there was a study put out recently in Science, and the Sentencing Project for the nation has put out several studies over the last few years concerning the impact on families and communities of the incarceration of those in the criminal justice system. As that moves on, it is simple to see some of the impacts, the economic impact, the housing impact. But what was most disturbing, honestly, to me in reading those were the health impacts. Not just mental health impacts of perhaps becoming an only parent, becoming a child without parental guidance, but also the physical health impacts that occur to family members, especially close family members, parents, siblings, children, of anyone who is incarcerated. It is literally shortening the life expectancy of people that are oftentimes in no way involved in whatever activity has gotten someone incarcerated. And it's also important to note that when I'm talking about incarceration, I'm not only talking about those people who have been sentenced, who have been found to have committed a crime, but also those who are awaiting a determination, awaiting their chance to contest what they have been accused of and awaiting their chance to defend themselves against whatever the state has brought forth. Those families are also dealing with the impact. The children of those families are immediately in danger. They are in danger of having their educational futures destroyed, in danger of mental health consequences, and in danger of falling into patterns without the guidance that they should have from adults in their lives. That increases, of course, with, as Judge Eskin talked about, how our rates of incarceration have increased. Some of the statistics I've seen, the rate of female incarceration has increased across this country, something around 775% over the last 40 years. So there are many more people, many more families, many more communities, especially communities of color, who are impacted by the decisions that are made every day and split up amongst different members of the criminal legal space.
Lemare, it seems to me that what you've just said expands the definition of victim. We traditionally have regarded victims as those who've been directly impacted by the conduct of a person arrested, but now we're expanding that understanding of what victims are to include the families of those people who have been arrested and prosecuted.
Yes, I believe that is absolutely true. And I think of affected people because I think victim takes so much power and voice away sometimes from people, but the impact, the negative impacts that occur, not collateral, specific personal core level damages that occur to family members can't be understated.
Now, Laura Pina, you bring a unique perspective to this discussion, one that's not been present in past discussions about criminal justice reform. When we talk about stakeholders, we've traditionally included the district attorney, the public defender, the sheriff, and the police, the court recently, and with good reason and success, behavioral wellness or mental health. You represent the interests of essential stakeholders who've been excluded from the table. Talk to us about that.
Yes, thank you, Judge. So I think Lemare just gave you a really good description of the family members that are impacted. And so that is my story. I am the wife of someone that is currently incarcerated. And so everything that she said is pretty spot on with what we go through. We ourselves, the families, are impacted. And as she mentioned, not necessarily just financially, but also emotionally. Often we are stigmatized, isolated, traumatized by things that are, as she mentioned, beyond our control. So for me, I think it was important to get involved here at the local level to kind of just not only understand and get involved in my community, but to be an advocate and a voice for those that are incarcerated. And in Santa Barbara County, there's not a lot of support or resources for people that are in my situation. Excuse me, I'm a little nervous. That are in my situation. So I had to look elsewhere outside. I leaned a lot on Los Angeles County, a lot of resources in Oakland and the Bay Area to be able to just educate myself and what all this means, what it all looks like, how I could help. And so I decided to join the League of Women Voters and the Santa Barbara Women's Political Committee to get involved in issues that are specific to women, being that I have 3 daughters of my own that I have raised, but also at large, just criminal justice in itself, and just to understand and learn what this is all about. So I have learned a lot. So going back to what you said, Judge Eskin, some of the initiatives that were opposed and some of the bills that were there, talking about and lengthy terms. We do have some upcoming bills that will be here in January that will help with some of these lengthy sentences. So I am looking forward to seeing how that will help. As far as something you said as well, the rate of crime, I know specifically for Prop 57, since it started back in July 1st of 1717. Between then and 10/31/21, 28,876 referrals were made. Out of those reviews, only 4,308 were approved. So we know that Board of Parole hearings is doing their due diligence and screening. And so often I think there is lots of scare tactics that say, oh, they're releasing people to come home, and that's not true. So I think that is huge. The work that Tanya and Tracy's office are both doing to have a more holistic approach and to have alternatives, I think is big, and it really should be commended for the work that they're doing. And as a community, I think we need to support them. They're open to change, they're open to listening, and I know that I appreciate the work that they are doing. So I think as a community, it's important to really, really support the work that they're doing, so individuals like myself aren't going through these struggles.
Thank you, Laura. We'll get to Tracy and her holistic defense in a moment, but first I want to turn to Tanya Heitman, our Chief Probation Officer, who's participated in an enormous expansion of her department's responsibilities. We're accustomed to thinking of probation as providing supervision of juvenile offenders and adults who've been convicted of offenses for which incarceration in the county jail and state prison is a potential consequence. But there have been some significant changes. And what are they, Tanya? Tell us about probation's role in pretrial release evaluations that preceded the pandemic and the impact of the court's emergency zero bail order on probation.
Thank you for that question, Judge. And I want to start by thanking the League and CLUE for the opportunity to talk about these issues today. I know there's great public interest in what's happening in criminal justice right now, so I appreciate the opportunity to respond and provide some background. So I'm going to take you back a little bit in time. Some of the history, I think, Judge, you've already covered, but I just want to hit on it real quickly, that a number of the local and state initiatives recently have recognized the unique role that probation departments were positioned to play in reform. Dating back to 2008, Santa Barbara County Probation Department, as well as others across the state, started training our staff on the use of assessment tools and exploring the use of evidence-based strategies. We implemented new strategies that were very successful at reducing commitments to prison, specifically on technical violations. That in turn led to AB 109, or realignment, which realigned supervision of populations that were previously under the jurisdiction of the state back to the counties. Realignment and the funding that accompanied it allowed us to look at our local criminal justice systems and start envisioning what we wanted to improve. Each county had some discretion in how they wanted to prioritize those funds, and locally we identified many priorities. But the two that are key to our discussion today is pretrial supervision and re-entry or discharge planning. Our local work in these areas was greatly enhanced as a result of realignment. And if you fast forward from 2011, when realignment passed, to today, we now have a robust pretrial program that allows us to consider a continuum of release options, everything from releasing someone on their own recognizance to providing intensive pretrial supervision and supports with electronic devices such as GPS or alcohol monitoring to assist those when appropriate. The discharge planning became a new focus as well. In partnership with the sheriff, the public defender, Department of Behavioral Wellness, and numerous community-based organizations, we began to offer supports and warm handoffs from jail to hundreds of justice-involved individuals. So when zero bail first went into effect as a result of the pandemic, in record time, we were able to systematically review 560 individuals within the jail to determine whether they were eligible for release and to design emergency release plans or provide information to the court to notify them of risk factors related to community safety that we
Excuse
need
me,
to be.
Tanya, let me interrupt because I
Sure.
want to have everybody understand is, what is this zero bail?
So thank you, Judge, for that clarification. It's a good point. When the pandemic first hit, jails and prisons were identified as congregate care facilities that were at risk in a pandemic, that normal procedures that others in the community were being encouraged, specifically social distancing, was not feasible in jails. So we recognized that we needed to immediately reduce the jail population. So the state, through the Judicial Council, put into effect an emergency order that reduced the bail amount, or that amount of resources that would have to be posted to secure somebody's release, was reduced to zero in most non-violent, non-serious cases.
And so did that increase the number of people who were released on their own recognizance?
It released individuals from local jails, some on their own recognizance, but locally, because we had the robust pretrial resources available to us, it allowed us to be more strategic about how we proceeded with release. Many individuals came under the zero bail order, but they were not well equipped to move immediately from a jail environment back into the community. So we were able to release them with additional supports and supervision when appropriate. And we provided that information to the court so the court could make the best possible release orders for them when zero bail went into effect.
So in other words, people were released from custody who otherwise would have been incarcerated, waiting for an adjudication of their case. And did we experience a huge surge in crime?
So no, we have not seen a big surge in crime rates in Santa Barbara County or across the state. There are some areas where there have been some crime increases nationally, homicides being an example of that the entire nation during the pandemic has seen an increase in homicides. But when you look at California in particular, those have not been as great as other communities have experienced across the nation. I think that overall, the research well supports that, in fact, communities that have lower incarceration rates saw lower increases in the homicides than those that had the highest incarceration rates.
Wow.
That, coupled with the extra supports we were able to provide individuals, they were provided with emergency housing, transportation, food, treatment resources to ensure that they could be moved back to the community as safely as possible.
So is this pretrial supervision support similar to the post-conviction support that probation provides?
That is absolutely correct. And each day, probation officers help sift through information and assessment to advise the court and provide those recommendations about how to address the community safety issues while addressing the needs of the population. We regularly serve as connectors to other service providers and partner agencies. And probation officers being trained in trauma-informed care, substance abuse treatment, risk needs assessment, a whole slew of what many see as a holistic approach to providing care to individuals has made the difference in the success of what we're doing here locally.
Did you just use the term holistic?
That's right. And I'm sure Ms. Makuga will want to speak.
Let's go there. Tracy Makuga, public defender. You are identified with the term holistic defense. Laura Pena did that this morning. Please explain what that means and how do you distinguish that approach, this holistic defense approach, from the traditional perception of the criminal defense attorney's role?
Well, first of all, thank you so much for the introduction. It is an honor to be here, and it's really nice to follow Chief Heitman because she has been a leader, and it's really refreshing because in the last 3 or 4 years, as we all continue to talk about whole person, trauma-informed care, community engagement, that we're all starting to speak the same language. I would like to say that I was the creator of holistic defense in Santa Barbara, but I was not. It predated me, and I want to use a football analogy because it's football season right now, is Family Services Health Agency, a community-based organization, envisioned a holistic defense practice for our office here and actually secured a grant to help us launch this. I just had the good fortune of being appointed at the same time and was given the football to run with it. And 5 years later, we have developed a very robust holistic practice, which on the heels of Laura speaking, I have to say, Laura encapsulates what holistic defense is. To date, the narrative on public safety has been on good and bad and punishment. And what holistic defense does, and I think what we need to do as a community, is recognize that there are Lauras that are impacted. There are brothers, sisters, or people that we sit at next to our churches or synagogues, or we run into a Trader Joe whose family has been impacted by the criminal justice system. Although my role as public defender has not changed, it is to defend and make sure that clients are given the best representation possible and to preserve their human dignity in a system that sometimes strips them of that. Holistic defense basically looks at each client and having a conversation with them to understand what their barriers are, what their path was that led them to where they are now, which is ensnarled in the criminal justice system. And Lemire just, she said it so correctly when she summarized what the criminal justice system does to families and what the criminal justice system does to our community. What we do is with each of those clients, in partnership with many people like Chief Heitman, with the community-based organization, we really work with individual clients in hope that not only we empower them to have their own voice and to advocate for them in the courtroom, but to help them knock down the barriers that prevent them from being successful. Again, if we look through the lens of each human being who comes into the criminal justice system as somebody who we live next to, or who we break bread with, or we see in the community, and see that we as a community, to make our community safer, have to empower them to be successful. That's what holistic defense is. And actually, I know you asked this question of me, Judge Eskin, but Lemire has been practicing holistic defense much longer than I have, and I would love for her just to build on my comments. Lemire?
Take it away, Lemire.
Thank you. I have been working in holistic defense for several years now and thinking about it a lot in my career. And the idea behind holistic defense is really that as our community sometimes, and as the players in the criminal legal system, we forget about connection and how powerful connection is to each one of us as human beings, as social creatures. And part of what holistic defense does is not recreate, because everybody has the ability to create their own connections and their own support, but sometimes really to strengthen what is there, to look at what do we have, what do our clients have going for them, with them, where were they in education, where were they in their health, in their mental health, in their physical health, with their family connection, and where are the areas where there's a gap. And in one of those gap areas, do we have somebody who has some skills to sort of build a bridge there? If somebody is trying to engage and is really just stumbling on making a connection due to a learning disability, or due to difficulty with anxiety and trying to read paperwork and trying to have an interview or something like that, if we have somebody as part of holistic defense who can step next to the person, not in for the person, but next to the person and say, hey, I can help you take a breath in this moment, right? I could help you grab some of those papers. I can give you a pen so you can do this here and now and not have to come back another day. And with the idea that when that happens, each time that happens, the person that we are standing beside is doing all the work, is taking all the steps, and is not going to fall off the path, right? We're sort of there to say, hey, like, someone is with you and next to you, because sometimes, as Tracy was talking about, what our system does is pull all of that apart sometimes from people. And as Laura talked about with the different stigmas, there are honestly sometimes people in our community who don't feel like they could step and be that connection for that person or with that person.
And if I can add just one comment, Judge, is, and I think Chief Heitman gets this, and we all are beginning to get this, is that criminal justice system for too long has done this one size fits all approach. And what holistic defense does, and a holistic, and then the probation side, is we're now looking at each individual and seeing them as unique ecosystems with unique histories and unique needs. And just like, cancer treatments have gone to personalized medicine and personalized approach, I think the criminal justice system is finally seeing that, and it's clicking that we have to take each human being one person at a time and solve and help them for their unique ecosystems. So that's what holistic defense really is at its core.
Well, I also think there's other perspectives. Like traditionally, we reviewed the prosecution and defense as adversaries and a competitive system. Prosecutors looking at wins or losses, and perhaps the same for defense attorneys. The traditional view of the defense attorney role, I think, has been to get the client off, which happens very infrequently. And it's much more realistic to look at the defense attorney's role as helping the client understand and deal with the issues that led to their being arrested in the first place. That seems to me to be the holistic approach, and probably much more effective in reducing the likelihood that the conduct's going to be repeated. But let's move on a little bit, because last week, on November 9th to be specific, the Santa Barbara Board of Supervisors decided to proceed with initial design plans for rehabilitation of the decrepit and obsolete main jail on Calle Real in Santa Barbara, but pause its long-range plans for restoration of the facility to provide an opportunity. I don't know how to turn that sound up.
Call from active geo.
But because its long-range plans for restoration of the facility to provide an opportunity for a projected population study concerning its future needs. Tanya Heitman, the term data dashboard or data dashboard was frequently mentioned during the Board of Supervisors hearing. Would you please explain this concept of data dashboards, what they are, how they're intended to function, and where our criminal justice partners are in their development and utilization?
Certainly, Judge. I'll do one better. Rather than just trying to explain it to you, I'm going to try to demonstrate it for you exactly what it is.
Great.
And how our community can access this information at any time now. The data dashboards are part of a transparency effort that we're undergoing locally to make our criminal justice information and data more accessible to the public. So what you should see on your screen right now is the probation department's public website. Anybody can access this by going to sbprobation.org. This is what we call our landing page. And if you go to the landing page and go down to this little box here that says Adult Services, click on it, and the last item in the list is Data Dashboard. You click on that, and it should bring up this dashboard that is demonstrating for you some of our criminal justice data in a way that anybody can access. So I'm going to talk a little bit just quickly go through some of the information on the dashboard. I will not have time to cover everything, but I just want to give the public an idea of what's on here. This chart up at the top is a trend line that if you hover over it, as I'm doing right now, you can see further breakdown of the information. So this happens to be a trend line of our supervised population. And the first box there dates back to December of 2020. And the more recent one is November of 2021. And as you can see, our population has gone down quite significantly in that period of time. That's a result of AB 1950, recent legislation that limited the amount of time that individuals would be on probation. Many are now exiting probation because they have exceeded the maximum time that they can be on probation. There's a number of different boxes here: closed cases, new cases. You have the ability to sort. For instance, and here we could check domestic violence, and rather than look at everybody, it will automatically sort to show the trend line for domestic violence. Or we can switch that to Prop 36, which is the old Substance Abuse Act, and where you can see that our numbers on Prop 36 are nominal at this point. Underneath the dashboard, there is a glossary. I know a lot of the terms that we typically use may not be familiar to the average person, so they can go on this and click on any of the terms there, and it'll give them a definition. This is an area that we'd like to expand, so as we get additional questions about the terms, we will add additional definitions there. We also have some FAQs where people can open up and look at why we're doing a dashboard or any of the other questions on there. And the last question is an opportunity to provide feedback to us. If you have some suggestions on how the dashboard can be improved, or you have a question about a term that's being used that you would like to have added to the glossary, you can click on the feedback form and submit those questions to us, and we'll update our website or respond back to you individually, whatever is most appropriate. I want to jump now to the sheriff's portion of the dashboard. It is a project that we hope to entail all of the criminal justice partners, and so far we have a couple that are online. The sheriffs, you go to their main website, sbsheriff.org. If you go to the command and divisions portion on the top, you'll see the data dashboard there. You can click on that. And again, it'll bring up a dashboard very similar to the probation departments, and a glossary of terms, as well as an email address to email questions or comments to. I'm going to expand this so you can see a little bit better. It's got a trend line. Theirs is a 30-day trend line that shows the jail population. And again, you can hover over the box, and it'll give you a little bit more drill down information. The ASB is Alternative Sentencing Bureau, so it tells of those that are actually serving their time outside of the jail on GPS. You can also look at any of the breakdowns of their population. For instance, this chart right here is a breakdown of those that are in custody during that month. On average, 85.36% of them were felons, and on average, 14.64% of them were misdemeanors. So the highest charge was a misdemeanor that was holding them in jail. We also have a chart for sentenced versus unsentenced. So the unsentenced being everybody that is not yet adjudicated, as well as those that might have been adjudicated but have not been sentenced yet. You can see the difference there. And as you can see, that at any given time, the vast majority of individuals in our local jail are what we call unsentenced. They have not yet received their sentence from the court. On the probation client one, it is a graphic that shows you of the population that's in jail right now, which ones are being supervised or had been supervised by probation prior to being in jail, and what type of supervision they're currently under. There's certainly more information that I would encourage the public to explore. These are, as I mentioned, easily accessible through the external website for each of the agencies. I would also mention that the district attorney's office has some statistics on their website as well, that you can access. Theirs is a little bit different, but as you can see, it too provides information that helps one get a better understanding of what the criminal justice system currently in our local community is experiencing.
So Tanya, these dashboards tell us who's in jail?
Correct. The sheriff's department's dashboard is specific to who's in jail. The probation department's is specific to who's under probation supervision. And then the DA's statistics show who they're prosecuting and what the final case closure is for those cases.
Well, there's some local political commentators who tell us that the jail is chock full of dangerous people. What do we know from the dashboards about the composition of the inmate population? How many of the people who are presently in the county jail are just there temporarily and will be going to state prison eventually? Is there any way of calculating that?
So, there isn't a precise way to guarantee who currently in jail is going to go to prison, because if they're unsentenced, that's still a decision that a judge needs to make. But I can tell you that for 2019, of all of the individuals prosecuted and sentenced throughout Santa Barbara County, 485 of them over the entire year went to state prison. So it's a very small percentage of our total criminal justice population. The reality is the vast majority of individuals in jail will be returning to our local community. They will likely get credit for time served or be placed on probation or do a year or less in county jail and be returned and be in our community again. So I think it's important that we keep that in mind, that when we say somebody is dangerous, that can be somewhat misleading when we recognize that they may have committed a concerning offense, a violent offense, an offense that warrants some level of incarceration, but it does not necessarily mean that they represent a long-term danger to our community.
Does it mean that the overwhelming majority of the people who are presently housed in the county jail are going to be released back into the community to re-enter our community within the next few weeks or months?
Absolutely. The reality
is, percentage of them will be committed to state prison.
For 2020, our most recent stats, about 7.8% of those that are in jail get sentenced to a long-term, or not a long-term, but a sentence in jail. 82% in 2020 of the people were going to be placed on probation. And then approximately 8% end up going to state prison.
I'm going to invite Public Defender Makuga to jump in here, but first, I overlooked a very important panelist, Pastor Jerry Menchaca, the founder of the New Beginnings Community Church, a native of Santa Barbara and longtime advocate for youth, who's devoted his adult life to the development of successful gang intervention programs and the Boys to Men Youth Mentorship Program. Jerry, welcome to the program. And what are your thoughts about what you've heard thus far concerning the composition of the population at the county jail and the limited numbers of people who are going to state prison?
Well, thank you, Judge. I appreciate that. Let me just thank the League of Women Voters also by allowing me to speak. Judge, there's a common thread that's said here throughout the conversations that have been happening. Number one, it's the domino effect that happens to families that are victimized by this over incarceration that we have here in the state of California. I have 19 years with the California Department of Corrections and with the logo as a senior chaplain. So I knew that the vast majority of these people that are in our county jails are going to be released to back into our local community. And I think the true concern of our local community to be is what can we do as a community to empower those men and women that are they're incarcerated, and how can we help the families that are being further victimized? I believe you said something to the effect that 1 to 2 weeks of people that they're going to do time in county jail, maybe 30 days, 90 days, or whatever it may be. But 2 to 3 weeks is extremely harsh on a family that lives a paycheck to paycheck. And these are people that are maybe get speeding tickets, fail to appear, something that are some minor offenses that are no direct have any direct danger to the local public, but get caught up in the system that they cannot really afford to be able to do certain things. So I think that, and it always is the people of color, minorities that don't have the financial backing to get out of jail. And if you have the money, Judge, you don't even have to show up to court. You can send your lawyer, and then the people at the lower end. And I appreciate our public defender's office and the great job that they do, but they're limited. They're overworked. They have stacks of clients, and they're so limited on what they can do for each person. So I think that the amount of people we have incarcerated, definitely not the answer. We've been doing this for many, many years, and there is and has not provided a well solution. So due to COVID-19, I think COVID-19 actually showed our community that if we reduce our jail inmates, they're not that crime is not going to increase. So if there's any kind of bright side, and I hate to even say that due to our COVID-19, it has revealed the deficiencies that we have in our criminal system, because we reduced the numbers tremendously and the numbers did not go up.
Tracy and Lemaire and Laura, jump in here, please.
Wow, I feel like everything that was just said feels like a mic drop to me right now. When you listen to Chief Heitman's data and just what the pastor said and building especially on what Laura said, is the vast majority of people in our jail are doing time in jail, and for the purpose and end result being what, if they're not going to prison. So we as a community should be investing heavily, not only in getting folks out reunited with their families and to connections that Lemaire keeps referring to, which is the human nature to be connected is what is the most stabilizing part of who we are. It's this holistic approach that we all are adopting is what's key, and getting more resources into the community to help serve the community we are all trying to say should not belong in our jail. Lemaire?
And I think also key to this is really thinking about, I mean, we are in a space and we, as many of us on this call, but I will say specifically public defense, is in a reactive space. We don't have any choice on who comes in, on who gets charged, on who's in jail. And we are reacting to all of those things, how someone is charged, what the level of offense is. And so I think it's important to remember that where those resources and things that Tracy was talking about is to keep people out of all of it before we have to react to anything. Before somebody has spent that day, I would even say a day in jail, is very detrimental to people. There are studies on juveniles for children that at one day, one single night in a juvenile detention facility can be detrimental to that child and that child's ability to succeed at the rate they would have. And so what we also need to be thinking about is like, how do we avoid that? It's wonderful that if as holistic defenders, we can wrap someone up in services and advocates and people, but so much better if that person had that shot before they were arrested, before they went into the jail, and before they ever had to see a judge.
Okay, the public's concerned about being protected from harmful conduct. What should we expect to accomplish during the period of time a person's incarcerated in a county jail other than his or her isolation from society? What needs to be done during that? during the time that they are temporarily in the custody of the county jail?
If I may respond to that,
Please,
Judge.
Jerry.
I unfortunately in my past, far past, I've been incarcerated in our local facility, and the everything that is taken from there, the humanity that's taken from them being herded into small cells and overpacked cells that are well over capacity in what they were ever designed to do, and putting them in it facilitates an attitude of anger and frustration. They're just holding people in cells. There's really not a whole lot of a program that is involved to address, what can we do, and really we never address who really belongs in there. They just kind of like a one shoe fits all, and everybody gets incarcerated, not even looking at the front end of this, saying like, well, how are we filtering these people that are going into our facilities? How is our facilities being overpacked with people that shouldn't even be there? And go ahead, Judge.
Excuse me, but Tracy, are these considerations that the Board of Supervisors should be taking up as they review design plans for the renovation of the main jail?
Well, from my perspective, yes. And I think those of us in the criminal justice space are advocating tirelessly behind the scenes and quite publicly about the design of the jail. But, the pastor hit it on the nail again, is that like right now today, I got the morning report and we have 708 individuals who are currently in our jail. 553 of them are unsentenced. 28 are incompetent to stand trial and suffering from mental illness.
Wait, Tracy. 700 plus in jail, 500 of which haven't been sentenced?
553 who have not been sentenced. And again, Chief Heitman is doing an incredible job of doing the pretrial release screenings. And, and we are all desperately trying to reduce incarceration. But when you do the math now, and what Chief Heitman was saying, if only 7% of them may end up or 8% in prison, the vast majority of those individuals sitting in our jail are coming back to the community. What can we do to prevent them from getting in there in the first place? More robust diversion and other options, but how can we get them out sooner? I mean, regardless, into alternative and home to their families. So yeah, but everybody is talking about it. Chief Heitman, I'm sure you want to join on this.
Yeah, I think that treatment space and safe spaces in the jail for people to be housed in a humane way are important. And we all want to advocate for that. And certainly that's what the board and the sheriff will be looking at in their rehab, remodel, and the reopening or the opening of the Northern Branch Jail. But I don't think that we can overemphasize that the key is to have them incarcerated for as short a time as possible. As Lemire was citing the juvenile study, that's one day, it has impacts. On the adult side, we're a little bit more resilient than children are, but 3 days is the cutoff on adults. If an adult stays in custody for 3 days or more, it adversely impacts all of their resiliency factors. So the sooner that we can get them stabilized and out, the better. But while they're there, assessment. We have to be engaging with those individuals to understand what their needs are so that we can formulate the best possible re-entry plan so that when they do return to their homes, their communities, serve as our neighbors, our coworkers, our family members, that they are equipped as well as possible with employment opportunities, educational opportunities, housing. And there is a lot that we can do while they're in custody to prepare them for that re-entry phase. The more resources we put into that, the better.
I'm sorry, I didn't mean to step on your line.
That's okay.
But you talked about people who are in custody now and their conditions. I'm curious as to whether these dashboards, whether it's yours or the sheriff's or the district attorneys or whoever, identify the people who are in jail as a result of conduct associated with mental illness.
So I think Tracy was just about to cite some numbers around incompetent to stand trial individuals in jail. Do you have that number handy for today, Tracy?
Number it was given today was 28 human beings who are suffering from mental incompetence that are currently awaiting treatment.
28 of the total should be somewhere else. They should be in a mental health facility.
Yes.
You know, I would add, Judge, that there is recent research that has actually found that if there is a drop in the availability of local psychiatric bed capacity, that it's associated with an immediate reciprocal growth in the local jail population. So I think we have to continue to advocate for appropriate psychiatric residential treatment options, both hospitalizations as well as lower levels of care for our mentally ill.
Well, another thing, sorry, go ahead, Tracy.
I just want to add one other thing. So if you all go back and look at the sheriff's data dashboard, now that's a static dashboard, it's not in real time, but it's consistent, the same information. A large number of people who are incarcerated are there for alcohol or substance abuse. Those are public health issues, people who are desperately in need of treatment, not incarceration.
Well, that's a lot more than the 28 who are there for mental illness.
Correct. And that what we see on the public defender side is every day in our arraignment courts, we are seeing individuals who are suffering from substance abuse, mental health issues, economic poverty, housing insecurity, every single day in our courtrooms. And incarceration is not a solution. It's something that will worsen their circumstances and only lead to the recycling of people through the system, unless, as Chief Heitman has said, we don't wrap our arms around and help with reentry. Preventive is the most important thing to me, but reentry plans that are better and will provide greater stability.
Are we putting the wrong people in jail? Or are there a lot of people who are in jail who shouldn't be there? That's an open question to all of you.
Yeah, I'll take a first swipe at saying that we definitely have people that enter into the jail or are in the jail that's not going to address their needs. It's not going to lower their recidivism. It's actually going to increase their recidivism. But do we have sufficient options for them? Do we have sufficient resources to redirect them to other programs? I think that is the question, and it's been further exacerbated by COVID. Yes, COVID allowed zero bail to reduce the jail population, but COVID also impacted people's access to treatment or diversion services. And we're now in a situation where that's going to catch up with us, that we have a lot of individuals who have been arrested and site released for substance abuse issues, and they haven't been referred to a substance abuse program. They haven't been assessed. They've been allowed to return to those same patterns without any intervention. And we've got to get on top of that and ensure that they get interventions.
Is that in part because the programs don't exist?
There are not sufficient programs, but I think right now in terms of the pandemic, a big element is that normally if I was arrested on a substance abuse charge, whether I was taken to jail or not, I would have a day in court and there would be some accountability for me. And right now, because of the pandemic and the lack of access, people aren't appearing before the court. They're not being screened for drug court or other options for diversion. They're not being told by a judge, hey, you need to go and get screened for residential treatment. That isn't something that is in play right now for a lot of individuals, not everybody, but for a lot of them.
Now, with regard to the mental illness piece, I'll call it that, there was discussion before the board last week of the success of something called a co-response team. What is the co-response team panel, and what is its measure of success, and how has it impacted the jail population? Who wants to take that?
I think the correct person to be here would be Dr. Lee, and that could be a whole nother panel, but a few comments. The Public Defender's Office was deeply supportive of the co-response team. In fact, the grant that the Public Defender's Office secured and took the lead is chief funding of the co-response team. So we believe in co-response, and we believe in the power of co-response. Basically, it mirrors a sheriff's officer with a behavioral wellness specialist, and they're called out to what would normally be described as a crisis call from a family member. And instead of leading to a person being arrested or incarcerated, the co-response team, the power of a trained law enforcement personnel with a behavioral wellness specialist, are able to de-escalate the situation and reroute that individual to treatment. But I would urge this group to bring Dr. Lee and the Sheriff's Department in to talk about the success of those programs.
Another term that was used, Tracy, during the Board of Supervisors meeting that people may not understand was discovery. What does discovery have to do with expediting the criminal justice process? And does that have any bearing on today's discussion?
I'm going to let Lemire answer that because you've heard too much from me. Because Lemire's on that work group.
So discovery is the evidence. What is this? What does the state have? What does our county have that in theory shows that somebody has committed what they are accused of? So it can be anything from pictures to written reports from law enforcement to body-worn cameras to neighborhood cameras to pictures and forensics as well, DNA testing of drugs and things like that. When we're talking about it as discovery, it's because somebody has been accused of a crime and their attorney is requesting that any and all of that evidence that would be held against them be shared so that our clients have the opportunity to review that, to let us know what problems there are, what's confusing about it, what it means, and to allow their attorney to have the chance, knowing the laws, knowing the elements of the different offenses, to say, wait, this matches, this doesn't match, wait, this is someone else, this is a different person, this is not, this is not what it looks like. Where that comes into play and why it was discussed at the Board of Supervisors is any delay in the sharing of that information that happens from law enforcement or from the DA's, the prosecution's office, means that delay gets passed on to our clients. Anyone who is accused of a crime has a constitutional right to know what evidence there is against them, what witnesses there are against them, and what is the full story of what they are being accused of. And those delays cause anyone, especially if they're incarcerated, to then require more time. So if that is not had, it requires time to get the information. Sometimes it requires time in special programs to download the evidence, to review the evidence. And then all of that has to happen before any of our clients get the chance to say, oh, wait, that's what we're talking about, or that's everything that's going on, and or what that means when compared to what the statutes say. And so there's an exponential rise in like time and continuances and pain and suffering for people who are waiting for that. And I think there's a psychological, there's a psychic cost that occurs to people who are awaiting, like I just don't know, right? There is a little bit of information that people get. There is an initial report, but to really understand what someone is being accused of, where it's coming from, that's where discovery plays into this. And I also want to say that one of the things that we have to also keep in mind is that everyone who is sitting in jail has not committed what they are accused of. There are 95% of people who are found guilty of felonies who have pled guilty, and 18% of those folks have been exonerated. They're later exonerated. 18% of people who have pled guilty to 2 felonies were actually in no way guilty of them. And it is issues like discovery and like incarceration that push those stats that cause people to plead guilty because something is going to occur. The charge will be lowered, or they will be released immediately, or they will go on probation, or it will be a shorter sentence. And the quicker that somebody is able to review and understand what's going on in their case and review that with somebody who is trained in the law, that is something that would, I believe, dramatically change those statistics, which we should all be horrified by.
Okay, I'm going to call out to our League of Women Voters manager of this program and ask whether we have any questions from the audience. Any of the participants who are in the audience would like to ask members of the panel questions.
We have a question that was raised by a really recent comment. Sorry. Last week, the Sheriff Department cited actually the number at the end of October was 634 people, or 600 and yeah, I think it was 34 in custody at the end of October. Why the jump to over 700 in today's report? I don't know if.
I don't think any of the panelists here are in a position to respond accurately to that question. We need the sheriff or somebody who's responsible for those citations. Sorry, that's not a question that I think these panelists can do anything other than speculate.
The other question we had earlier was about the controversy over the Sheriff's Department's cooperation with ICE, and what is the status of that issue, and what is the effect of that connection on public safety in Santa Barbara?
Well, that too is an excellent question, but I don't know that any of our panelists are in a position to respond with personal knowledge. Anything else, Gail, that?
We have quite a long comment from Lynn Gibbs, who I think also raised this in the hearing last Tuesday, a week ago, Tuesday, which I think is a really interesting comment that people may want to respond to. In her role with NAMI, she communicated with a mother whose child spent 2 years in the jail prior to being moved to a state hospital, not guilty by reason of insanity. There he was at last given a correct medical illness diagnosis and accepted effective psychiatric medication. He's now a team leader and a mentor to 40 patients in his unit. Imagine if he could have gotten this treatment sooner. What are the plans for the locked psychiatric treatment facility outside the jail, for which the Community Corrections Partnership set aside millions of dollars in 2016 or 2017?
I think Tracy's going to tell us we need Dr. Lee.
Actually,
No,
I think I can take that one.
Wait, Chief Heitman.
As the chair of the CCP, that one's the one that I'm a little bit familiar with.
Oh, great.
So as was noted in the question, the Community Corrections Partnership did put aside money in our reserves for a mental health rehabilitation center. It was originally proposed to be a lock facility that would serve clients within our criminal justice system that required the security of a locked environment, but due to their mental illness, the jail was not the best environment for them. When that money was first put aside, there was a belief that we could rehab part of the old Santa Barbara Juvenile Hall to accommodate that facility. A study was done to do that, and it was determined to be a viable option, but our local behavior wellness director at the time decided that they wanted to pursue a separate site that they thought would serve them better over the course of time. So they did a separate study on a site out on Cayo Real in Santa Barbara. That too was found to be an acceptable site that it could happen on, but the amount of money needed to rehab it was greater than was originally anticipated. And in the meantime, the Champion Center in Lompoc began providing services to local mental health clients in a locked environment, or had the capacity for that. So they've recently asked us to fund, using those funds, a pilot of 2 beds at that facility that is up and running now, and are currently studying whether we should continue to invest further into the beds at the Champion Center, or if the MHRC at Cayo Real should be an option. That is under discussion right now, and we will be relying heavily on behavioral wellness to provide analysis of which option is best. My gut feeling is, based on the early discussion, is that there's a great likelihood that they're going to want to continue the pilot at the Champion Center and perhaps expand it to allow more patients while we continue to gather data on the long-term needs and what the most appropriate options would be. But I think that we can easily say that the CCP, or the Community Corrections Partnership, would agree that there should be greater capacity for mental health needs in a locked environment for those that fall into that IST category, but also some that maybe are not in the IST area, but just have very serious mental health issues that are exacerbated by the jail environment, and we would like to provide a better option for them.
Well, Tanya, that's what I thought when I heard Pastor Jerry tell us about the experience of being marched into these isolated cells. Maybe the space at the old main jail that's going to be renovated to some extent should be redesigned to provide for those kinds of expanded uses of the space, not tiny little cells where people can go be housed while they're in the jail and deteriorate mentally and physically and not be better off than they were when they arrived. Jerry, tell us a little bit more about your experience and your recommendations here. What would you say to the Board of Supervisors going forward with its plans for revitalizing the old jail?
I would say to them that what can we do to not to perpetuate and to continue to use the old model that has not provided to be useful. When I was there in our local county jail, and you lose your freedom, you're separated from your family. There is nothing that is done in when I was there that addressed, what can we do to help you? What could have been done different? What could be provided? The programming that we have, a lot of times when people are put in Santa Barbara County Jail, they don't have the cross communication with all the different programs that are available. I agree with the panel is saying that there's not enough, but that stuff that is there is not presented to them. It's not considered taken as a consideration for them to say, listen, this person really does not belong in a county jail. They need a mental health, with alcoholism, drugs, whatever it may be. And when you put them in that environment, people get, they get so much more aggravated in the sense that, what can I do to help myself? And nobody's there to really help you. Currently our officers, which I think there's some really good men and women who provide service for our community, are not really properly trained to say, how do I communicate with this segment of society? What can I do? What the things that I should not do to make a bad situation worse? Because really, most of them they're not trained. They're trained to simply, as long as they're safe and they're locked up. That's about the furthest that I've seen it ever happen. So it's nothing really that I think it's the limit of the training that's not provided for our officers and those that are in there.
Can I
Laura?
step in?
Can I add something?
Yeah, let's call on Laura.
I think off of that, I think it's also important for just not only the county supervisors, but all entities of the county criminal justice. I know Tanya has it, I know Tracy has it, but just hiring practices and job descriptions. Tanya's, I looked at job descriptions and they're there, with that culturally competent information as far as hiring. So hiring practices, I think that's also important. You're getting people that are trained or understand whether, you know, again, culturally competent, very holistic base with a angle to be able to handle, you know, a lot of this that's going on. So I think, you know, it going back to, again, the county, you know, looking at your hiring practices, looking at your job descriptions, that's also something that is key when we want to think about county level as well.
All right, well, I'm going to turn to all the panelists and ask, are there any issues we haven't addressed here today that you want to speak to? There's an open-ended invitation.
I would just like to make this comment to build on Laura, and I think it's important, is the criminal justice system talks about people in the other status. We use words like inmate, defendant, and I think we have to change our language and how we speak about the community that we're serving, because these are human beings that are incarcerated. And I think as long as we allow ourselves to talk that way, it's easier to sort of separate ourselves out. And so I would like to suggest to this group that we all try to holistically name and use naming conventions that are more humane and show more dignity and respect for the people we serve. And then lastly, this community group and others have really empowered the Board of Supervisors to start taking actions that reflect our community values. And so I would urge everyone to continue to be a voice at public hearings, to be a voice and get more people at the Board of Supervisors to affect change that we all are desperate for. And we know the families that we serve are desperate for. But thank you.
Thank you, Tracy.
Judge,
Well
if I
said.
could just make one more comment. I think one of the things that really truly need to be addressed is changing the subculture that is prevalent in almost every facility that I've ever been in. I've served probably in state of California, probably well over 10 different state facilities, 8 different county jails. And there's always been a subculture of us against them. It was really relieved at the LA County jail when they had those fights going on, organized fights, and it was organized by the correctional officers. I think we really need to be able to say what more of an us against them mentality and more of a us as a community. What can we do? There's people there that are accused for crimes that have not been convicted, but they treat everybody as some sort of mad criminal. And everybody's put on that same level, not really losing the ability, they lose their humanity. And a lot of that's perpetuated by the training or the lack of training with our correctional officers. Again, I understand the most difficult job that they have, but understanding how to deal with people and the lack of communication ability and everything comes from, us against them mentality. That subculture needs to be addressed.
You're right. On the outside, we're all community members.
Okay, I've just been asked to check the chat box about a question from Dr. Peter Hasland, but I don't see it. So Gail, can you?
I can
give
read
it to me?
Yeah, it's in the Q&A.
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 Oh, I'm sorry. I think I know how to access that.
You just press the Q&A button.
I don't have it at the bottom of my screen. I'm sorry.
Incarceration while awaiting.
There we go.
Do you see it now?
Ruth Ackerman.
No, go all the way down to
I
the
see.
last question.
Incarceration while awaiting trial would seem like the opposite of, quote, an innocent until proven guilty, end quote. Do we have a serious process by which to separate people who may be a threat to public safety as opposed to those who pose no threat? I was really impressed by the comments of harm being done to those who serve 3 or more days behind bars. Do we have a process? Well, there is a process. And the process rests with a entity that has escaped attention today. That's the Superior Court. And the fact of the matter is, although we don't speak of it, judges have the authority to effect a drastic reduction of the jail population. First of all, A majority of the people who are in custody, as we've learned, are in pretrial status. That means they've been accused of committing a crime or presumed to be innocent, but have not yet been convicted. They're entitled to bail unless they've been accused of a capital offense or a felony offense involving acts of violence on another person, felony sexual assault, when the facts are evident or the presumption's great, and the court finds upon clear and convincing evidence that there's a substantial likelihood their release would result in great bodily harm to others. So there's almost a presumption that a lot of those people who are presently in jail today should be released from custody. The original purpose of bail was to provide a method for release from custody, but excessive and arbitrary bail schedules adopted by judges throughout California have converted bail into a method for detaining people in custody. The Supreme Court of California this year ruled that judges must consider a defendant's ability to pay when setting a cash bail amount, and it's unconstitutional to detain people in custody solely because they can't afford it. Nevertheless, judges frequently find it convenient and risk-free to adopt a bail schedule prescribed for the offense. The current bail schedule should be drastically overhauled to comport with the principles of the In re Humphrey decision, and judges should expand the number of participants in pretrial supervised release programs. Second, after 50 years of experience with diversion, the legislature this year gave judges authority to offer diversion programs without requiring the consent of the district attorney. And judges should be more proactive in utilizing the provisions of Penal Code Section 1001.95 in appropriate cases. This is just retired Judge George Eskin speaking. But third, judges can suspend the execution of prescribed jail terms for a term of probation that requires active participation in drug treatment, mental health, job training, and education programs designed to address the underlying conditions that contributed to the criminal conduct for which the inmate was convicted. These actions will not occur until someone takes on the responsibility of asking the question of every person in custody, why is this person in custody? But Peter, that's where the answer is. We could significantly reduce the jail population, including those who are there for 3 days, if these issues were addressed with every inmate. That's this guy's response to the question. I don't know, do any of the other panelists want to talk about Peter's question?
I was gonna say, we gotta ask the why. What is the root? What is going on? But that why is very important, Judge.
Anybody else want to contribute anything before we thank the League of Women Voters again for this opportunity to air these issues in public?
Judge, I just want to, I agree with the concerns about asking the why and looking at the public safety risks. But I just want to also cast a little bit of a light on the other element, which is getting them to come back to court. The failure to appear is another factor that the court can consider in terms of raising bail if they're concerned they're going to abscond or not return for future court hearings. And we are at a moment in time right now where that is going to be an even greater concern than it has been historically. That during the pandemic, a lot of people got cited and they did not go to court and warrants were issued. So by the time they come before the bench, by the time that they're in custody, they have racked up a number of warrants, which is going to drive up the concern about their willingness to return to court. And with a population of individuals that have substance abuse problems in particular, that is going to be a factor that we have to contend with. We have to recognize that if you're an addict, if you're suffering from some type of alcohol addiction, drug addiction, there's a good possibility you are not going to make your court hearing, and then their risk of failure to appear in the future is going to be greater, and they're going to be held in custody potentially. There are some creative solutions that may be able to be utilized, but it's not quite the same situation we had before, and we're going to have to look at that a little differently.
Those are absolutely valid observations, Tanya, with which I agree. But I'm also aware of the fact that it was tough. It still is tough to get into court. You walk up to the courthouse and there's a sign, public prohibited. I mean, I'm hoping that my former colleagues will be receptive to explanations from people. They didn't come to court because they couldn't get in. The signs told them they weren't welcome. And I'm sure that
Well,
may affect some people.
I think we'll have to interrupt all of the assumptions that are behind this, all of the assumptions that are behind why somebody didn't come to court, why somebody is acting the way they are in court, why somebody was in court and left court. There are so many assumptions and biases that underlie those initial decisions. And so the idea that a warrant goes out because somebody didn't show up to court is actually based on an assumption that they are not there because they meant not to be there, that they're doing it on purpose and that they are affronting the respectability of the court, right? There are lots of assumptions built into that. And we spend so much time, I feel, in a space of what someone can just do. Like someone could just get a car, someone could just get a ride, someone could just pay this amount of money, someone could just do this, when oftentimes those spaces are specifically unjust. They are specifically the things that we cannot do, that our clients cannot do, that our neighbors cannot do. And until those are dismantled, until those assumptions are dismantled, we will spin into just another reason that somebody's getting incarcerated. Like right now, it may be warrants and failures to appear. Later, it may focus on substance use. After that, it may focus on a different type of concern, but it's still going to be that underlying unjustness and disproportionality that underlies all of this. And until we take a minute, because I think all we need to do is take a beat, take a little bit of time and say, wait a minute, is that right? Should I be thinking about this way, or is it possible? And I think that's where our decision makers need to be. Is it possible there is almost any other potential reason?
Well, Lamar, I think the legal term you're referring to is willful. Is there a willful failure to appear? All right, Gail Osherenko, on behalf of the League of Women Voters, do you want us to simply say goodbye and thank you, or what else, anything else we should address?
Well, there's a last question here. Who will lead the judges to change?
Okay, moving right along. I'm not going to put Lamar on the spot. I'll put Tracy on the spot. What do you think, Trace?
I can tell you we're advocating for change, and there are spots where the district attorney's office, probation, all of us are shoulder to shoulder on issues to affect some change. And quite frankly, it's old-fashioned litigation. Back to the core function of what a public defender does is we're just going to have to be more aggressive in our courtrooms and litigate more of these issues to push those kind of changes.
We have some other questions here, but I think what I can say is that they lead to the discussion that we'll have on December 1st, when we always have discussion group after some period of time after the panel. So hopefully you all will come back on December 1st and we can really talk about what are the best options for the jail remodel. And, shouldn't we be spending that money on rehabilitation, sober living, mental health, things that LaWanda Lyons-Pruitt is suggesting here. And we haven't gotten to some of the also tougher issues about how what we're talking about today links into the national call for police reform, and how a holistic approach leads into that. But it seems to me a little beyond the scope of what we envisioned for this panel. And so unless somebody wants to.
Well, I want to express my appreciation to Pastor Jerry Menchaca, to Laura Pina, to Lamar Kyle Griffiths, to Tracy Makuga, and to Chief Tanya Heitman. Thank you so much for participating today. I'm really grateful for your contribution to this discussion. Thank you so much. And a big thank you to the League of Women Voters.
And thank you, Judge Eskin, for great moderation.
My pleasure.
Yes, thank you for pushing the issues with us and asking the hard questions. Good discussion.
Thank you.
Goodbye.